I'm wondering whether you've seen the affidavit from the Chief Justice, and then we'll further go to the response from the Attorney General. What's your initial reaction to it?
I saw snippets of it. I have not read.
All right, so let me just run you through briefly. She talks about denial of basic right, where she says that she and her lawyers were barred from using phones or laptops during hearings, while petitioners' counsel retained full access. She talks about invasive searches, where she underwent searches and denied family support, unprecedented venue, why the Osu Council was chosen instead of the court complex as applied to other Article 146 proceedings, also procedural irregularities where petitioners were allowed to avoid testifying in person, rather relying on witnesses, and a few other stuff that she talks about.
Okay, let me start from the last one. If you are talking about the petitioners not testifying in person, I do not know if such hearings, in terms of abusing evidence, whether it is different from all other hearings that we have, because the law has always been that it is not compulsory for a plaintiff. So in this case, we are just replacing the plaintiff with the petitioner to testify personally. And we believe that this was the same principle that was used during the time that we were doing the electoral commissioner, the electoral hearings, when Jean Mesa refused to take the stand. Okay, so if you have persons who can duly testify, I believe that satisfies the law. So I would not want to put so much weight on that.
So you don't think that the AG has the CJ has a case with this point?
Because this has always been the law, that a petitioner, okay, or a plaintiff, let us use the generic word to stand for all people who initiate processes, court processes. A plaintiff is not under any legal obligation to testify in his own case. And so, for instance, there have been many cases where somebody may have probably bought a piece of land or done something in his name. But probably he himself does not even have a lot of information about the process of acquiring it and all that, and who led in getting the land and all that. And so you can sue in the name of that person, yet the person who takes the stand and mounts the witness box to testify on behalf of the plaintiff may be different from the plaintiff himself. And so if that is anything to go by, then my thinking is that we should not belabor such a point, because it is not offending any rule of law as we know it.
How then, Lawyer Alex Abban, how then do you interpret the description of the CJ in this instance where she says that the petitioners, in fact, let me start from a bit where she says denial of access into the hearing room for my husband and children, searches on my body, denial of access to telephones and laptops for myself and my lawyers, and says that the conduct of hearing itself in a high security zone at the premises of the Castle Osu show a deliberate effort to subject me to mental torture and degrading treatment in violation of my fundamental human rights, and goes on to say that the persistent violations of her constitutional rights show the whole proceedings initiated against her are a mockery of justice and a ruse to unjustifiably remove her from office as Chief Justice. How do you interpret these descriptions?
I am on record publicly to say that the grounds on which the state or this whole process has been set in motion are not weighty enough. In fact, I went to the extent of saying that even you cannot even remove a judicial president with these things. But this is something political, so we can just forget about that and move on. But as far as the hearing is concerned, I share some of her concerns, because if we look at Article 17 and Article 23, which deals with equality before the law, it also has to do with equality of treatment, right? And if you look at Article 296, it also talks about treating everybody fairly without any ill will or malice or something like that. And so if all other parties who come in have access to things like phones, laptops, and all that, but she is denied, then I think that is actually a travesty of justice.
Having made that admission, others think that perhaps the Chief Justice is not conducting herself well in this whole process. Do you disagree with them?
I don't think the Chief Justice would conduct herself any less nicely than the way I know her. So anybody who says that the Chief Justice is misconducting herself may have to bring proof. Because I'm speaking as a person. I've known her for many years. I have actually conducted cases before her. I've won cases in her court. I've lost cases in her court. Right? And she has always been very, very fair in the way she conducts herself. And so it will come to me as a huge surprise that within this short period, her normal demeanor would quickly change for the worse. I doubt it.
The AG obviously but what you?
Yes, but what I'm saying is that if indeed there are these searches and all that, I think we should leave out some of these excesses and deal with the issue of the fact or the allegations before the committee.
Let me ask you my last question.
In fact, if you look at Article 196, Clause 10, I think it is Clause 8. It is Clause 8 that says that these proceedings should be held in camera. As at now, there has not been any definitive judicial pronouncement on whose protection this is meant to be.
Don't forget as well that Article 146, I believe from 6 to 10 also talk about in camera as well.
Yes. And I'm saying that whether it is for the protection of the person who is the subject of the investigations or it is to protect the sanctity of the whole process. Mind you, the position has always been that in any proceedings, except probably for matrimonial issues, all other proceedings are supposed to be in public. And that is the default.
You have to pardon me. We're running out of time. I just want to get this response from you. What do you make of the AG's response? Saying, for instance, one of the main points the AG says is that in-camera hearing is a constitutional command geared at safeguarding not only the CJ but the entire judiciary. It can therefore not be waived. He goes on to also talks about the request of the CJ to remove the justices, Justice Esiedu as well as Kwaman from the panel.
Let me talk about the first one. The first one being that the in-camera thing is a constitutional mandate or constitutional command. That is true. But the point is that we have not had any judicial pronouncement on it, as I was saying earlier, whether it is for the protection of that person or for the sanctity of the entire proceedings.
So that's something that must be reviewed.
So whatever the Attorney General has said is his opinion.
I'm sorry, we'll have to end it here. Thank you very much. Lawyer Alex Abban, private legal practitioner. Thank you so much for sharing those views with us now.